podcast of the PPO, podcast about everything from the world of public procurement. Dear listeners, welcome to another episode of Public Procurement Office podcast. Today, I speak with another interesting guest, Mr. Professor Piotr Bogdanowicz from Warsaw University in Poland.
Hello.
Hello,
Nice to be here.
Piotr. Thank you very much for coming to our podcast. Could you please introduce yourself and tell us how you actually got into the procurement field?
Okay, so I'm professor of law at the Warsaw University, the chair of European Union law, and I focus academically on public procurement because I always was interested in public law and fields that are connected to what the state does. But at the same time, I'm also a practitioner, focusing on infrastructure projects, which are often connected with public procurement because contracting authorities were building roads, power plants, or other infrastructure often have to apply public procurement. So basically I'm looking at public procurement from two perspectives, academic and more practical one.
That's great. What did you find out so far?
My last book was about modification of public contracts, which was, I think, an interesting study of how rules may impact the performance of the contract. So whether contracting authorities are bound by rules after the contract is concluded, and of course they are, but this is something which is quite new in public procurement because until 2014 and the current public procurement directives, there were no provisions on the modification of contracts. Basically, the legislation focused on the stage of awarding the contract and ended then. And quite recently, I started researching such issues as the access to the public procurement market by entities from third countries, or the relationship between, on one hand, this new EU policy by European against the policy that is developed in many countries, including Poland, local first. So whether states may promote selling or purchasing products or services which are provided by Polish local entities, or they are banned by internal market regulations. Again, I think that when you hear public procurement, it does not sound sexy, and I would never say that public procurement is sexy, but it's not that boring. I would even say that it's quite interesting.
Okay, so let's start with the Polish current situation. What are the biggest challenges you're facing right now in this field?
There are a number of challenges, maybe starting from the fact that contracting authorities often try to secure their positions to the possible fullest extent. So to give you a flavor, they often propose selection and award criteria which are not that connected or not directly connected with the subject of the procurement or the contract, or imposing on economic operators a number of contractual penalties in terms of the failure of the contract, or setting a performance bond at a high level. So basically, or as a consequence, discouraging potential participants from the procedure, and as a consequence, on average, public procurement proceedings got 2.5 bids each time. So basically, the contracting authority chooses between 2 bids only, and I think that if some conditions could have been relaxed, and the law allows to that. So it's more the case of practice and not of legal provisions. That would be with benefit for everyone. So that's one of the challenges I see. The second one, which one may say it's a challenge. The second one is the other may say that it's an interesting thing. A lot of litigation in Poland. So when you look at statistics, I think that there is no second country in which there are so many litigation before the first instance, because each year we have around 4,000 to 5,000 appeals, which means that even if the contracting authority selects an economic operator, you can always or nearly always expect that there will be an appeal, which of course extends the duration of the proceedings. Then often you have an appeal to the court. So this is a big challenge, I would say.
What about bureaucracy? Do you think the public procurement processes are now in Poland, let's say, like really acceptable as a processes, or would you really welcome if it would be simplified?
Simplification is a buzzword now in the European Union. So when there are discussions about new directives or new regulation, simplification is often put as one of the reasons for such revisions. But the question is, what would it mean in practice? And then my point is rather to professionalize contracting authorities, to show them that they may be more flexible than changing rules. So, in other words, I don't think that rules are bad. In principle, I would say that they are quite okayish. The issue is rather with application of them. And then getting back to what I said a few minutes ago, the question is whether you really need to require high performance bonds in the proceedings, right? Or whether indeed you need to impose in drafts of the contracts contractual penalties. Maybe that is not needed. Maybe you don't need to require all of these documents that are required. So I think that this is more, I think, of challenging topic than bureaucracy itself or something related to.
Because actually many of these higher demands from the contracting authority are truly supported by all these directives coming from European Union. They are, encourage use green, use social, and so on and so on. So someone would say this is actually, Poland is performing very well if they are actually following these suggestions, because let me tell you, this is definitely not the situation in Slovakia. In Slovakia, still the biggest, most common criteria is the lowest price. It is, of course, connected to all this controlling system we have here, but we are not in the situation where we can actually say, yes, the demand for the quality is this high as you mentioned in Poland.
In Poland, indeed, the situation is then different than in Slovakia, but it does not mean that it's perfect, unfortunately, because even if quality criteria are applied, they are often set in such a way that each and every participant meets the conditions based on quality, which as a consequence means that still the price is the one which decides, right? Because if you have 2 or 3 criteria, one will be price, 2 others will be quality, or based on quality, but they done in such a way that each and every participant will meet them. Then we back to the price as a criterion, and this is I would say the challenge, right? So I think we already passed through this gate that quality criteria are important, and then again is to educate, to professionalize contracting authorities, to show them that they don't need to be afraid to apply more complex criteria based on quality, because often they are afraid. They are afraid that some controlling body will come and say, guys, what was the basis of selection of this entity? Why this entity is better than the other one? If you have a price, that's a binary, right? Because 7
it's objective.
Is more than 5.
Yes, and it's objective with the price, because this is exactly what is happening here. The contracting authority has the full responsibility, and the controlling organ comes and actually is trying to tell them why you shouldn't use this criteria. But they have the responsibility to actually who is going to award the tender. It's a very complicated situation, and the controlling organs, I think, play the main role. That yes, we just make it the easiest way possible. We just say, okay, let's do it with the lowest price.
Yeah, that is one of the reasons why PPP in Poland, so public-private partnerships, did not develop, because PPPs often comprise lengthy negotiations. So it's not just the award, but lengthy negotiations, because entities and contracting authority, and unfortunately, some people say that there are 4 P's in this PPP. So not only public-private partnership, but also prosecutor, which comes later, and that's a pity.
Let's move to European level. So what is happening right now is that European Union is trying to exclude third countries' economical operator from the tenders, is actually transferring this responsibility for the contract authority, which, for example, in Slovakia can be a mayor of 200 inhabitants village or municipality. This is the reality that we are heading to right now. What do you think about these changes?
Yeah, so that's one of the, I would say, most interesting developments in EU public procurement law recently, because the Court of Justice stepped into boots of the European Commission. The European Commission was passive as regards issuing any guidelines or proposing any amendments to public procurement directives to clarify the rules on which entities from third countries can have an access to public procurement markets, EU public procurement markets. And the Court of Justice, in this well-known judgment of Collin and anything there, said basically that these entities do not have this access, that they do not enjoy rights to be treated in an equal and non-discriminative way. Which resulted in different approaches in different member states. For instance, in Poland, different outcomes. In Poland, we revised public procurement law, and now the law clearly says that these entities do not have, as a rule, by default, do not have an access, but the contracting authority may accept them. But even if they accept them, they cannot benefit from any remedies. So basically, contracting authorities may accept them and propose conditions which will not guarantee these entities any equal treatment, non-discrimination, etc. Well, that's the question how we define fairness. And when we look at the public procurement as a policy tool of shaping economy, then probably I would say it falls under the definition of fairness in a way that if these third countries do not treat EU economic operators from the European Union in a fair way, then they do not ensure equal treatment or non-discrimination, then basically the EU does the same, right? On the other hand, and this is what such scholars as Marko Turudic from Zagreb or Pedro Teles from Copenhagen are saying, is that this goes too far. If EU wants to exclude entities from third countries, it can do, but rules should be more transparent. And again, just to give you a flavor, now the European Commission says that these entities can be excluded at any stage. So even if they are accepted, the contracting authority still have the right to exclude them if, for instance, if it changes the mind, which indeed is very, very far-reaching, or that they should have the right to remedies. So if something goes wrong, if the contracting authority accepts them, then remedies should follow, right? Because otherwise they will not be treated fair, to use your notion. And it's of course always a bigger picture. And a bigger picture is whether we have sufficient number of entities from the European Union that may carry out specific proceedings, or at least in some cases we do need entities from these third countries. So a really big topic comprising not only law but also politics, economics, and I do hope that in new directives or new regulation this topic will be treated with a scrutiny.
I'm going to dig deeper on this because you have already this regulation in your national law codex. I think it was adopted last year. So now maybe you could have the first data, what it did on the market. Poland is a huge market. We are definitely not comparing Poland to Slovakia in these terms, but do you already have some first data as to what it did? Why am I asking? This decision by the Commission can truly lead into actually buying more expensive. Then why we have procurement as such? Because this was all meant to have the processes on how to be economically right, to save taxpayers' money and so on and so on. But now these regulations, which I also totally understand are to protect kind of the European market, can lead to different results. And you belong to the countries who actually have recodified your system, so maybe you can share with us what's your feelings and what's the results.
Yeah. On one hand, the data are telling, so these new regulations basically excluded entities from third countries. So contracting authorities do not accept as a principle these entities. And now in for instance, construction, public procurement, we do not have entities from Turkey or China as we used to have.
Like not at all, or it's just a huge decrease?
It's something between not at all and really, really huge decrease. So 95% or so. So only in exceptional situation they are accepted, and not in the construction sector, because we have a number of European entities, sometimes also present in Slovakia, like Budimex, which is a big construction company active in Czechia and in Slovakia. Or Strabag, POR, or Polish entities like Mirbut, etc. That's one thing. The second is that, interestingly, it looks like that it did not cause the increase of prices. So still the level of competition is quite big and did not impact much the market. But of course, as you say, less entities may lead to the increase of prices because the level of competitiveness is lower, right? So it may depend on the sector itself. The one I know, so the infrastructure one was always very much competitive in Poland. So when you have a new tender that relates to the construction of some infrastructure, you often have 10 bids whatsoever. But on the other hand, there are proceedings in which you have just 1, 2, and that is why on average you have a small number of bids in Poland.
Yes, but we are talking about the big market, which is Poland, but let's compare to Croatia. Because sometimes I feel when I have this podcast with the representatives from the smaller country where I also cover Slovakia, these suggestions from European Commission are really not so problematic for the big markets, Poland, Germany, France. But when we come to these small markets like Slovakia or Croatia, who is really very much involved in business with Turkey or China, as you mentioned, it might be like the real problem for these countries.
That's true, and this is what Marko Turugi says, right? That in Croatia, basically, calling judgment was not accepted. So the data are totally opposite than in Poland. So only in few cases, the contracting authorities decided to reject offers. And as always, not only in public procurement but in other fields as well, I think that the answer is in the principle of proportionality. I mean, if you have a competitive market, which means that in any case you will get many bids in any case, then probably you don't need such entities, right? But when you have a market in which you have 2, maybe 3 bids, or there is a risk that there will be just one bid, and if there is a one bid, then probably it's higher than through competitive process. Then you need to take it into account, right? And you may, that's what comes from the judgment, you may apply so-called adjustment score, right? So basically promote national or European entities against bidders from third countries. So basically you may achieve the goal, but at the same time still take into account the situation you describe in smaller countries.
Tell me, what are the requirements I have to meet if I'm considered European company? So the one that is not considered like the third country economic operator.
What do you mean?
I mean, let's imagine I come from Turkey, but I will just create a permanent address. Yeah. The address, for example, on Polish, somewhere in Poland. I will get my identification number as the company and so on and so on. But my mother company is in Turkey, for example. Am I considered as the third country economic operator, or am I considered I am acceptable in this process?
So that's a good question, which is, by the way, was under investigation recently in Poland, because a sole fact that you are owned by Turkish parent company, Chinese parent company, etc., should not count. This is what I would say as a principle. The more important thing is whether you will rely on capabilities of this entity, or you will be subcontracting works or services to this entity, which in such a case would count. But a sole fact that you are owned by should not. However, there was a judgment of Polish National Appeals Chamber in which the chamber excluded an economic operator just because it was owned by third country entity. The case was appealed to the court. Unfortunately, I was told that it was dismissed based on some formal grounds. So basically the court did not say a word about this. The real matter. Yeah. It was just on the process through necessities. So imagine, if I got you correctly, I am, for example, company from Slovakia. I will come to your tender, but my supplier, sub-supplier will be 80% from Turkey or China. Does this mean I am not accepted in this tender? Yeah, so what is the percentage you accept and what is not? Yeah, so we are not talking about the percentage as regards, but if you rely on capabilities of entities from third countries, they will not be counted. This may be excluded by the contracting authority. Yes, my question was to what extent I want to imagine how in real world, because I know you're a practitioner, how in real world this really exists, because there are probably some goods who actually cannot be even delivered from other countries, but China, for example. So just because I also offer some scale of the tender from this country, am I immediately excluded, or am I still part of the process? Yeah, so on goods or on supplies, we basically apply EU public procurement directives. So look at whether this amount of goods from third countries goes beyond 50%. So this is the threshold. If it goes below, then it is okay. If it goes above, then such an entity will be...
I will be more specific because I was talking more about in the case of constructions. But in most of the constructions, you also have parts that are, maybe I didn't use proper word, goods, but simply some subjects that maybe cannot be found on the European market. So this was more my question, like how then are you going to differ if this offer is accepted or not anymore?
Yeah, so if it is the case that a specific good can be delivered by one entity or
for example,
or four entities, but all of them are out of the European Union, right?
Exactly. This was exactly my question.
This is your question. To my knowledge, this is acceptable by contracting authorities, or would be acceptable under Polish law. And this is actually something which I would say is reasonable, right? Because again, it's not against competition. It's not about competition against competition between EU entities and third country entities, but it's for objective reasons where you cannot basically get given goods at EU market.
And do you think if actually this approach is adopted by the European Commission, is it better to have it as the regulation or as directives?
Well, another $1 million question. I think that directives fly well, and I'm not fully convinced that regulation is a proper panacea on problems we have. And my main argument is that I'm afraid there is no one single procurement market. Public procurement markets are different, and contracting authorities are different. There are contracting authorities which are much more mature, like in Western countries in particular, where they may apply some flexible solutions. They are more experienced and sometimes just more brave to not to be afraid that a controlling entity will come and say that there was some corruption whatsoever. Whilst in countries like Poland, Slovakia, Croatia, still there is a room for improvement, for bigger flexibility, for simplification, and I'm simply afraid that if we will have to apply just one specific rules without any reference to national peculiarities, which directives give for harmonization process and not unification, then it might lead to not good outcome.
And really, honestly, do you think that this direction that Europe is heading in the public procurement processes are really going to help actually with the economical issues that we are facing at this moment?
Yeah, so the question is whether, I think that the question might be a little bit different. So whether this is driven by economics. And I think it's not. It's rather driven by sometimes security, but sometimes just politics. There are studies which are saying that local content and supporting local entities against European or even entities from third countries does not bring an economic value, because it's against competition, against competitiveness, and then basically you will not get additional points for that. But this is something what EU countries are doing, again, as a tool of shaping the purchase policy. So not even as a tool regarding strictly economics, to increase economics, but rather to tell today voters, we are protecting state-owned companies. We are protecting state. We are protecting you.
I totally understand this political aspect, but for me it's very important to hear your opinion as an expert, not only on the economic field, but also from this practitioner point of view, like what are really the real economic impacts. Because yes, politicians very often promise some things, so we can see it in Slovakia for many, many years. But there are some now real expectations that can be already suggested that what it can actually truly bring.
Yeah, so to the best of my knowledge, there are no such data now. How does it impact economy or public procurement market? The problem is that when we look at cross-border procurements, often numbers are very low because very rarely contracts are awarded directly to foreign entities which have sit in other member states. Often, and again, let's look at the construction market, Strabag, POR, or other entities from big capital European groups participate in public procurement proceedings through Polish subsidiaries, right? And basically, they are not counted in this cross-border data exchange, etc., right? At the same time, contracts that are awarded to entities from other countries, those who are not in the European Union, even from GPA, are often marginal. And if they are awarded, they are often awarded based on, like in the defense sector, based on international agreements or G2G, government-to-government procedures, and not based on public procurement. And that's a challenge. And I think that's one of the studies that should be carried out. What does it mean? I mean, that's a very good starting point that world is changing, that we look at the economy and how we may use it indeed to increase or to develop the economy.
Thank you very much. Would you like to share some last comments with our listeners?
Basically, I would underline the importance now of public procurement or looking at it from different perspective as a study which is really interesting. So those who are already involved, keep going. Those who consider whether public procurement is a field to dig in and to study, research, or use, my answer is that go ahead.
Thank you very much, Piotr. It was really great to have you here.
My pleasure.
You were listening the podcast of Public Procurement Office with Petra Šupakova.
Podcast of the PPO. Podcast about everything from the world of public procurement.